Hey everybody, I'm JD Hoovener, owner here at Bold Patents Law Firm, and I'm here with Matt Kulseth. Matt, good morning, good afternoon.
Good afternoon. You're used to saying good morning because we used to do
I'm
this in
so
the
used to good mornings.
morning.
This is our fourth show in the afternoon. We're here every week, 1:30 Pacific time. That's 4:30 at the end of your workday on the East Coast. We're talking about intellectual property and specifically patents, trademarks, and we'd love to take on any questions you've got in the arts as well on copyright and trade secrets. This is a live broadcast for Facebook, LinkedIn, and YouTube. So we welcome anyone that's visiting us for the first time. Give us a like and share this with your social folks, with your community there. We've got an action-packed day today. We're highlighting not on a guest, but on Mr. Kulseth right here, our resident expert on trademark. No, that's you, sir, right up front. We're going to have you go start to finish on what trademark law is, when you need it, how to get started, all the way through the end. Is there, and that's the funny thing is, right? Maybe you'll tell us there may not never be an end to your trademark once you get one.
Sure.
So that'd be really cool. So that's coming up very quick. We're gonna hear from Matt. As I said, any live questions that come up, we'll be taking those as priority. Throughout the broadcast today, we may end up answering the 4 preloaded questions that came in from our beloved community on Avo. We've got Lancaster, Pennsylvania, Doylestown, Pennsylvania, Seattle, Washington, my hometown, and League City, Texas. So we have those questions. If we want to get to those, we can, Matt. And then we also have our giveaway. Today is our free 20-minute screening session for those that are watching this broadcast now or check it out afterward. This is our weekly live link. And hey, Hammy, my little boy's here. He's got a bracelet. Ham, want to say hi on air? You're live on camera, Ham. Say hi. This is my boy Hamilton.
You're famous. You're like,
yeah, he's famous. You're on TV.
Yeah.
All right. That's awesome. Nothing like that. He's home sick. He didn't look too sick today. But yeah, he's hoping to go back to daycare tomorrow. And
future influencer.
Oh yeah, yeah. He is. He really could be. He really could. He's very chill. He's not quite as intense as me. So I lost my train of thought completely, but that's okay.
We've got questions to answer potentially. We'll go through some trademark stuff. We'll answer some questions.
Yes.
Are we doing a bull bite today, JD?
I do have a bull bite set up. I was trying to find one kind of in, tennis, because I've been watching personally a whole lot of US Open lately.
Cool.
I know anyone else watching, but I couldn't find anything on point. But we do have one queued up. It's about a dog care product or pet care. So yeah, I thought that was pretty across the board. Oh, Ham got a so cute. Look at that. I'll make sure to pass that along. Okay, so cute. Or maybe they're talking about you, Matt. I don't know. All right, so we're gonna go. We're gonna go right to you. I'm gonna put you up solo layout, if you don't mind. There you go. The stage is yours. So trademark law. Enlighten us. I will poke and prod, and I'll make sure to let you know if we see any live questions come up.
Yeah, that sounds good, JD. So hello, everyone. Yeah, so I'm a trademark attorney. I've been a trademark attorney for 11 years and work here with Bold IP. Mostly do trademark registration with the United States Patent and Trademark Office, and we do a fair amount of litigation as well. And our trademark team here is myself, and then we have a senior paralegal who's been doing trademark law for like 15 years. But again, like I'm only focused on trademark law. So let's talk a little bit about what is a trademark, why they're important, and how do we get one, right? So trademark law, like historically, if you go way, way back in time, probably the earliest cavemen and cavewomen who were doing drawings, I'm serious, were actually like putting their names, not their names, but their symbols basically on drawings. In more recent history, I'm talking like Middle Ages and feudal Japan, you saw people using their brands, their personal identification, symbol on Japanese katanas, swords, basically. So the importance of branding and putting a maker's mark on your products goes back for centuries. When we talk about like in modernity trademark law here in the United States specifically, we're talking more about the Lanham Act, which is in the 1940s in the United States. And the Lanham Act really is a consumer protection law meant to protect consumers against the likelihood of confusion from various trademark infringement. So a trademark is a source signifier. So it identifies a product or service. And these are very important in society because when you go to the grocery store and you're looking for Tide laundry, you know exactly what Tide looks like. It's the big orange bottle, with the circles, right? It says Tide. There's no confusing it for another brand on the shelf. If we didn't have trademark law and trademark exclusivity, you might go to the grocery store and you might see a wide array of brands that look and feel just like Tide. And you might be confused as to like who's the actual provider of that service or that product. So that's what trademark law really is meant to do, is it's to protect consumers from confusion as to the source of products and services. We use it a lot more in the concept of intellectual property and an ownership right today. And it's really an enforcement right that businesses have for basically creating these products that consumers come to know and appreciate. And what trademarks signify is goodwill associated with that brand. So it's the goodwill of the company. It's the goodwill of the product that's associated with the company providing that service or product. And trademarks can be extremely valuable. They can be valuable for small businesses, but they can be extremely valuable for large publicly traded corporations. If you think about Tesla, for example, publicly traded company, right? And what that brand is worth, as an example, and you add up all the shares of the stock that's out there available for purchase today, you get an enormous number, right? I'm assuming it's in the billions and billions of dollars, right? It's worth a lot of money. If you take that sum and you back out the liabilities and assets of the company, you're still left with an exorbitantly large number. And what does that number signify? It's not product. It's not the debts of the company. It's not any of the cars that are in the factory. It's all of the goodwill of the company. It's the trademark. So that brand can be worth a significant fortune. And it's no different with small businesses, right? If you have an exclusive right to use the trademark and you build up a clientele over 10, 20, 30 years, and you go to sell the business, you'll typically want to sell the intellectual property rights of the business, including the trademark. So why are they important today? There's a number of reasons. If you have a federally registered trademark, you get exclusive use to that name in all 50 states and territories. Beyond that, you have the ability to enforce the trademark. And not only do you get rights to the exact name, you get rights to anything similar to that. So like, for example, Bold Patents, the name of JD's firm, right? If somebody were to come along and call themselves Strong Patents or Bullish Patents, that would be a violation of JD's rights potentially.
I'm actually Googling these right now, right, Matt? Okay.
Yeah. Because basically they're a synonym for bold, right? Brave potentially patents would be a violation of JD's rights because they sound the same in some fashion and they mean the same thing. So you get exclusive rights to any trademarks and related services or products that are similar in sight, sound, or meaning. It's like that trinity, basically: sight, sound, and meaning. Now, back to why they're important. Enforcement. If you want to enforce your trademark in federal district court, you have to have a trademark registration on file and enforced with the federal government, the United States Patent and Trademark Office. If you want to enforce your trademark, your brand on social media, which is huge for a lot of clients right now, because a lot of companies advertise on social media, Facebook Marketplace. They do a lot of education, entertainment on YouTube, TikTok, LinkedIn, Facebook, all those platforms. If you want to enforce your brand on those social media platforms, you have to have a trademark registration, right? If you are a product company and you want to sell your products on Amazon and you want the fancy A+ pages that are like a homepage for your business, for your products, you have to have a registered or applied for trademark with the United States Patent and Trademark Office, and then be able to apply to Amazon's brand registry. So lots of reasons. Beyond that, licensing, franchising. If you franchise your business at some point, you're going to have a trademark registration on file for the franchise disclosure documentation. Also very important.
Sorry, Matt, interrupt you.
No, go ahead.
I know you've talked about before. I want to come back to social media. Social media. Let's take that. Let's go one level deeper on that. What's an example? So you're saying that I'm not, in order to have a business page, let's say on Facebook, maybe the most well-known social media, you're saying it's, who requires the trademark? How does that work?
Yeah,
When do you,
good
what are the
question.
issues that can come up?
Yeah, so obviously anybody can, sign on to Facebook and open a business page potentially, right? But if you are the federal trademark holder of that trademark registration, and somebody else is impersonating you or doing something very similar to you on Facebook with a similar name, then by all means you can shut that Facebook page down. And Facebook is very accommodating when it comes to trademark enforcement.
That's
If
cool.
they're using the exact name or a similar name, plurals, throwaway words like the in front of things, they are more than happy to pull that down and give you back your page essentially. But
Now,
you
should
have to do
someone just
registration.
okay? Should someone just approach Facebook on their own, or should they seek counsel first?
Yeah, I would always recommend seeking counsel before you go file cease and desist with folks and take down notices on social media, because
Okay.
there is always the possibility that these folks have better rights than you do to the name, and you're going to go kick a hornet's nest by trying to enforce trademark registration. I mean, it happens to clients. I've seen it happen before. We get a trademark registration and the client wants to go enforce it. And all I ask is that clients just call me or email me before they go, if they want to do it themselves, because it doesn't take much work for us to go take a look at it and give them some, sound advice about if they should enforce the trademark against this company or not, right? We can basically figure that out pretty quick.
Awesome. And I just put in your email address there for anybody that's
Yeah,
listening now or after the fact to matt.kulseth@boldip.com. Any questions about what you got? Can I take you all the way back, Matt?
yeah,
Let's say I'm thinking about a really cool name, and I'm way before, I'm pre-business.
love it.
What are some initial steps? And then what is maybe the first step where I would hire you to help me?
Yeah, that's a good question. And it's kind of changed a little bit, to be totally honest.
Okay.
So early and often is when I want clients to reach out to me with potential brands and products, when it comes to naming, right? There's a couple reasons for that. One, we want to make sure that before the client's investing in marketing, logo design, packaging, all those things, that essentially basically we're clearing the trademark so that we know when we do file for it, we're going to get the registration. So that's number one. Don't invest in something until we know we can protect it. You're not going to be violating somebody else's trademark rights. The second reason is the USPTO process is extremely, extremely long, and it's gotten so much longer with COVID.
Yeah.
It used to be, JD, that I could tell clients like, hey, please, before you go to market with anything, let me know 6 months in advance, which was a lot. That's a big ask for a lot of clients, especially first-time clients, right? They don't know.
Right.
But that way we could clear the trademark internally, file it, and get the get the initial approval from the USPTO in about 3 to 4 months. And then they can go to market after that and know that they're going to get the trademark registered.
Okay.
It's not really possible today because the USPTO is so far behind, right? When we apply for a trademark today, we'll be lucky to get examined in 9 to 10 months, which boggles my mind. It's bad. We've had clients who we worked with, we filed the trademark, they got pregnant and had a baby before they actually got the trademark registration, right? Which is crazy. It's like a lifetime.
Yeah.
So just know that the process is extremely long, and anything you can do to file that trademark before you go to market is going to save you a ton of time on the back end.
Okay. All right. So, and there's definitely a bit of a search, right? There's the knockout search effort.
Yep.
When do you search? Do you always search? Walk us through that search process.
Yeah. So when it comes to the soup to nuts, what a trademark attorney does, we're really responsible for a few different things. One, we need to know what the client is, what their business is, what their specialty or niche is, how they make their money, and what their long-term goals are, right? So we just need to understand the client and really have an idea of who they are and what their goals are. Then, depending on how unique or, in trademark parlance, distinct the trademark is, we'll conduct a thorough, formal search. We're looking at registration at the USPTO, availability, meaning you're not going to get sued for using it, freedom to operate, basically, and then how strong is the trademark if we're able to register it. Those are the three things that I'm most concerned about. We have that search done. We write the opinion letter basically saying, hey, we're good to go, or we feel that there's an issue with this particular trademark application or registration in front of you, and here's how we propose to get around it. So there's a strategy to it. We prep the application, we review with the client, they sign off on the application, we submit it to the USPTO, and then basically babysit it through the whole, 12 to 14 month process. Yeah. So there's a few steps involved in the trademark application process, but the search is really important. The only time that we don't recommend searches for clients, there's a couple of reasons. One, the search is more expensive, right? So some clients just aren't willing to pay the additional money for the formal search in opinion, and we totally get that. We always conduct a knockout search for the client though. So looking for major red flags that would say, hey, like just can't do it, not going to do it. Because the last thing we want to do is sign up a client and work with them and get a denial without the client having full awareness of that. Denials happen; it's impossible to get around them, but the client should be aware of that going into it. And then the only other times that we basically would say, hey, like just move forward with the application is if the client has what we would call a coined trademark. So a trademark that they basically just made up out of thin air. Like say like they're an HVAC company. They call themselves Zolio. I don't know what that means, but they call this random name, right? It's coined. It doesn't mean anything. It's not a foreign translation. It's not a last name. We look it up and we're like, yeah, that's a made up word. We're going to file that without doing a formal search and opinion.
Got it. Okay. And then a question come in from our live LinkedIn users. Is trademarking your name and logo the same process and cost? My name is in the logo.
Great. So this kind of gets back to like the nuts and bolts of the trademark application and putting the application together. Number of different things that go into a trademark application, including who the owner is, what the trademark is, how you would describe it, the goods or services involved, when you first started using it, yada, yada, yada. Boring stuff. But what they're asking is like, what's the difference between like protecting a word mark versus a design mark? So trademarks can be a whole bunch of different things. They can be word marks, protect the characters of a name. They can be a design mark, which protects the logo. It can be a slogan. They can even be smells. They can be noises, if you can believe that. And they can be trade dress, like the interior of a McDonald's restaurant. Primarily, though, 99.9% of the time, we're talking about word marks and design marks. Word marks obviously protect just the letters of the name, no claim to color, font, logo, stylization, design elements. Whereas a design mark protects the logo, which could include the name of the business or the product or the service. Generally speaking, if we can get the word mark, that's going to be your best, value for your money, because a word mark is very easy to enforce because it's not curtailed by the design elements. And if you change that logo in the future, we don't have to refile the trademark application. If you have a design mark on file and you change the logo 5-10 years from now, well, then we basically abandon that trademark registration with USPTO, and we technically need to file a new trademark to protect the name or the new logo. So word marks are really important. Sometimes clients will do a combination of multiple marks, maybe a word mark here, a design mark over there, because lots of clients have different classes of services and products that they sell at the United States Patent and Trademark Office. So,
hey, Matt, we got a live question here. That was awesome. Thank you for that answer. Bob, it's got a question here. He's been in business for a while, and he wants to know, can someone secure a trademark if they've already been using the name for a while?
Yeah. Yep. So trademark rights in the United States subsist upon use in commerce, which is a fancy way of saying that you're selling something, right? And today that could be online. It could be in the olden days, if you had a store on a highway, federal highway, that counted as interstate commerce, right? You ship stuff across state lines. Today, everyone is in interstate commerce because it's just the nature of the economy. So you have to have the trademark in use in order to get the registration certificate. You can apply before you're in use, but the United States isn't going to give you that registration until you go to market. One other interesting thing about trademarks is some clients have what we would call descriptive trademarks, meaning that they describe the product or the service. So like if, Bold Patents, instead of being called Bold Patents, was called JD's Patent Firm, that would be very descriptive of the firm and who owns it and what we do. But there's the possibility, if JD's got a pretty cool logo and he's been using it for more than 5 years, we can make an argument. And of course, he's famous. He's on the internet.
Right.
Um,
Although my son is getting more comments for his 5 seconds.
Right.
Yeah, right.
So we can make the argument that JD's patent firm has acquired secondary meaning in the marketplace and is thus entitled to registration on the principal register as opposed to the supplemental.
Okay.
We want to be on the principal. We don't want to be on the JV register.
Right. Okay, Matt. And by the way, we're going to skip the bold bite because there's too much to go. We're sticking with trademarks all the way through here. This question is a little bit. I'm going to weave it in. This came from our Avvo community. When you're filing the exact wording, okay, the words themselves, do you need to worry about? In this case, this person asks about misspellings. Okay, so here is the example. They want to trademark their brand for the word likable, as in likable shoes. Should I also file for misspellings?
No, don't waste your time or money. Okay. And the reason is we talked a little bit about how trademark registration protects you from similar trademarks that are similar in sight, sound, or meaning. Likable, no matter how you spell it, I don't care if you have an E in there, you're missing an E, if you spell it with a C, it sounds the same and the meaning is the same in the mind of the average consumer viewing the brand or hearing about the brand for the first time. So that being the case, you don't need to file multiple trademarks to protect different iterations of that similar name, right? That's the beauty of a trademark registration, is that it's a pretty broad scope of protection. And it gets even broader the more niche your product or service is. So in this particular case, likable shoes, file it exactly how you use it, because that's the only way you're going to get the registration. You can't have multiple iterations of a mark and use it in multiple different ways and expect to get registration. And then you'll be able to force it against anyone who comes along with a similar name.
Awesome. So you're going to get coverage. You don't need to file a bunch of misspellings. That'd be a silly waste of time. Awesome. Okay. Another LinkedIn news. LinkedIn's blowing up today. Are simple name patents any quicker to approval than others?
Okay. I think they mean trademarks, obviously. People get confused about trademarks, copyrights, and patents.
Yes.
Happens all the time. So are simple name trademarks any easier to approve than others? Yes, potentially, and no, potentially. It just depends on the brand, and I guess that's the easiest answer is that we've seen some, clients come through and we've, registered trademarks for one letter potentially in a design mark or 2 letters in an acronym. Sometimes they're harder to register than a 10-letter word. The only time we can get trademarks through the system quicker is it basically if they have anything to do with COVID, right? If they're a medical company like bringing a COVID product to market, we could potentially file the trademark and get it approved faster than the typical 10-month examination process.
Okay. Well, Matt, we're going to rapid fire question mode. We're in the last 5 minutes here. This question kind of sounds like a legal, final exam question.
Yeah, let's do it.
A little math feel. I feel like you've been warmed up. I think you're ready for it. So here it is. Okay. I think it's if, not of. If I do a trademark search with AAA, BBB, CCC, does it also cover a search for AAA, BBB? Or do I have to do a separate search? Just wondering if a trademark search covers all word combinations within the original phrase, such as if it were truncated.
Good question. And again, it depends, right? I hate saying that because that's just a cop-out. But in this particular example, your brand, if it's AAA, triple B, triple C, would prevent anybody else from registering AAA, triple B, right? They're too similar, right? But that is
Say that again for me. So
in this particular example, if you were trying to register AAA, triple B, triple C, right? Yeah. And somebody else tried to come along and register AAA, triple B, or even double A, double B, that would be a violation of your trademark. The United States Patent and Trademark Office would deny their application based on your previous application or registration.
Okay, got it.
But certainly there are lots and lots of brands out there in the United States. Something like 20,000 trademarks are filed every week in the United States.
Every week?
Every week. It's crazy. It's tripled since I've been an attorney for the last 11 years. So, it depends, and client or the potential client should, email me. We can talk about it.
Okay. We got the last question here. This is going to be crossover copyright to trademarks.
Yeah.
It's a long one. It's going to be, this is good. So can I copyright the overall format and non-written as written curriculum for an after-school program? It is kind of back to school season, so it's good. It's a good question. So can I copyright the overall format I'm the founder and director of an after-school creative arts program that does biblically centered creative content for
Cool.
theater, dance, singing art, creative journaling. I would like to copyright the theater pieces that are written as well. Here we go. And
General format of the
as well as
program.
the general format of the program for creating journaling curriculum and name and tagline of the program. How would I go about doing that?
Okay, great question, right? So there's a lot there. Your general curriculum, right, in terms of how you put a program together, the piece of paper, the physical piece of paper, right, how you organize it. The organization is not able to be copyrighted potentially, but all the words and all that kind of combination of design elements are a work of art in terms of copyright protection and can be protected. You don't need to run off to the Copyright Office and file them with the U.S. Copyright Office until you're looking to enforce them. But just put, copyright your name and the year that you created the work at the bottom of each of your pages. And that's what all my law school professors did. Copyright J.D. Hubner, 2022.
Right.
And that's how you signify your rights to a copyright in the United States. The name of the program, the slogan are trademarks and potentially registrable with the United States Patent and Trademark Office. Like I said, the curriculum is, but if you're organizing it in a traditional manner, like for example, like if you did an A to Z format in terms of the curriculum and not by date potentially, you couldn't register the copyright to those certain elements because they are common, if that makes sense. But anything that's original and has an artistic endeavor, such as how you format the explaining the program or the seminars in it, those are registrable as copyrights.
Cool. So in terms of trademarks, it would be the curriculum itself. If you title it, name it, or maybe the actual creative works, the performance, the name of the event.
Now, from a trademark perspective, this is an educational program, right? So that falls into class 41 at the USPTO, education services, right? Namely, a program for educating children in a church environment for X, Y, and Z.
Right on. Okay, we have a couple minutes left. Get your last questions in. Matt, wrap us up. I mean, this is rapid fire. Any last comments on trademark law from your words of wisdom?
I mean, trademarks are fun. They're valuable. They're fairly low investment, I think, in terms of what they're ultimately worth to the end user. They're important for enforcement, and they're harder to get than they've ever been because we're talking about a limited English vocabulary, right? With a lot of interest in participating in it, and a lot of people interested in copying what other people are doing. So they're harder to get. It's more important than ever to work with a trademark attorney to search, file, and ultimately register your brand. And
Love that.
We'll have fun. Call me. We'll have fun.
Okay, do it. Set up a meeting with Matt. He is fun. We're gonna wrap up, everybody. Thank you for joining. Again, give us a like, share this with your community on social. We're here every week, so if you miss us live, we're going to be back 1:30 next Wednesday, 4:30 on the East Coast. So goodbye, everybody. From Matt, I, and Bold Patents, we wish you guys a great rest.